welcome everyone. Welcome to tonight's Acts 2 workshop, Estate Planning for Dementia Caregivers, What to Know and Actions to Take. I'm Dr. Robert Glukov, Servant Director of the Acts 2 project and Professor at Florida State University. For those of you who may not be familiar with Acts 2 is the African American Alzheimer's Caregiver Training and Support Project 2. I sincerely hope and pray you will find this workshop both inspiring and highly informative. Before I introduce this evening's presenters, I want to recognize our partners who have contributed both resources and guidance in the development of the Acts 2 workshop, Dementia Care Workshop Series. Our Acts 2 primary collaborators are the African Methodist 11th Episcopal District, the Florida State Primitive Baptist Convention, the Florida Progressive Missionary and Educational Baptist Convention, the Florida General Baptist Convention, the Florida Department of Elder Affairs, and the FSU College of Medicine REACH Project. Turning now to our tonight's presenters, we have three exciting speakers. I promise you, you will enjoy this. Mrs. Barbara Moore, attorney Jami Coleman, and Mr. Cornelius Falk. Our first presenter, Mrs. Barbara Moore, lives with her husband and actually her college sweetheart, Kenneth Moore, in Rockledge, Florida. They have been married for 55 years, folks, and have two children, and have had 2 children and 5 grandchildren. Barbara and Kenneth also raised their niece after her mother passed. Mrs. Moore received her bachelor's degree at Tuskegee University and subsequently underwent graduate studies at both Florida A&M and Nova University. Mrs. Moore is currently retired, or maybe I should say actively retired. She previously held leadership positions as president and CEO of a large nonprofit organization in Brevard County, and as a certified Christian educator for the National Baptist Convention. She was also vice president of the Women's Auxiliary for the Florida East Coast Baptist Association. In her spare time, Barbara enjoys reading and writing, as well as hosting family outings and also dinners in the home. Our second presenter is Aisha Coleman, who is an attorney specializing in estate planning, tax law, probate matters, and business law in the Leon County area here in Tallahassee. She has held leadership positions in several organizations, the Legal Aid Foundation, Project Embrace, Big Brothers, Big Sisters of the Big Bend, and has served as a mentor for youth in Leon County Public Schools and for law students at both FSU and at FAMU. Jami has spent most of her life in Tallahassee and is a very passionate community leader. She is dedicated to the welfare of persons in Tallahassee and the surrounding areas. Last, we have Mr. Cornelius Falk, who is happily married and a father of 4 wonderful children and 6 grandchildren. He was born in Charleston, South Carolina, lived there until he moved to Atlanta, Georgia, where he attended Clark College. He received his bachelor's degree at Clark College in public relations and was later commissioned in the U.S. Navy. Most of Cornelius's professional activities have been involved with governmental agencies, and I would like to emphasize his work in bringing justice to victims of crime in the Orange County area. Mr. Falk is also a facilitator and recruiter for the Acts 2 project and former caregiver for his dear grandmother with dementia. Cornelius enjoys cooking, singing, and fishing, especially with those 5 grandchildren. During the course of our 3 presentations, I would encourage you to please use your chat function, your text messaging function to present questions to each of the presenters. They will have a few minutes after each of their presentations, and then we will have 10 minutes, folks, toward the end of our workshop to answer any additional questions. Now I would like to introduce you to Barbara Moore. Take it away, Barbara.
Thank you. And thank you for inviting me. It is certainly an honor to be a part of this workshop this evening. Again, my name is Barbara Moore, and I'm happy to share my story this evening, as well as my experiences in the Act 2 program. I have had many titles and positions in my lifetime, but nothing is more vital and more important to me than the title I have now as caregiver for my husband. It is one that I never saw coming, of course, and it certainly was not on my vision board. This new chapter in my life and journey began probably about 4 years ago when my husband began having fainting spells. It was after 3 incidents and trips to the emergency room and several doctor's appointments later that I learned that he had been having many strokes. This had not been detected in the first several trips to his different medical appointments. He also began having difficulty following directions, and even when he used the GPS. On occasions, he would forget how to drive his stick shift vehicle. As music director, he also would begin playing the same songs over and over again in our church worship service. After realizing that there was an issue, I began to gradually take on the responsibility for our family's finance, doing all the driving and other tasks. These were all new roles for me and things that he had traditionally been responsible for. It was still many medical tests and many doctor's appointments later before he was finally diagnosed with dementia. By this time, I was really taking full responsibility for the business affairs in our home. As time passed and the days and the weeks unfold, my husband needed more and more of my assistance for our day-to-day tasks. As life as we knew it had certainly changed forever. However, my faith in God gives me great comfort. In Jeremiah 29:11, God assures me that although I don't know what is ahead, He does, and He assures me that His plans for me are to prosper me, not to harm me, and to give me a future. So it was by His divine intervention that He led me to the Acts 2 program. God used one of my friends to first tell me about the program. In fact, she told me that she was attending a church service and she saw an Acts 2 fan in the church pew. And she immediately called me and told me I needed to enroll in the program. And certainly I immediately enrolled. This program educated me about all aspects of the dementia disease, as well as provided information about community resources that I would need. The ACTS team members were very caring and very helpful. Our class facilitator was knowledgeable and she showed personal interest in each of us and our individual situations. We learned strategies for dealing with our day-to-day difficult situations, and we set goals and identified strategies for not only taking care of our loved one, but even strategies for taking care of ourselves, and that was very helpful. I truly look forward to each session and kind of saw it as a retreat each week, preparing to go to each session. She made it very enjoyable. Our facilitator was also very gifted in engaging the team and making us feel safe in sharing personal issues that we face from day to day. As a result, we not only learn from the facilitator, but we learn from each other as well. I have just completed the 12 weeks program, which gave me confidence in my role as a caregiver and has certainly enabled me to fully engage this new chapter in my life and the journey that lies ahead. During one of our class sessions, the caregiver mentioned that she had prepared a memory book for her husband. And I felt that this was a wonderful idea, so I decided to make one for my husband. I wanted to engage him in the process, so I made it a fun game. I interviewed him, and together we wrote his life story. We selected pictures from my vast collection to match the story that I had written about him. In the process of putting this book together, I thought how this book had been so helpful and so beneficial to my husband. I also thought how useful this could be to my family when my husband and I are no longer able to help or answer questions, or when life ends for either or both of us. I must admit that this was a very emotional time for me. It was not an easy task. In fact, it was a grieving process for me. However, I knew it was necessary and it was something I needed to do. In fact, I would prefer to do this than to later on have someone responsible for this task. So I began to put together the legal document section of the book: power of attorney, the will, the insurance, and other legal end of life information that we would need or our family members would need. In addition, this whole process gave me peace of mind, really, that we had completed this very important task. Everything we need or someone else would need when we are gone is included in this book. We completed the book, and my husband and I thoroughly enjoy reading the beautiful story of our 55 years together as salt and pepper. This is what our friends call us. One never without the other. Where he goes, I go, and that has been our lifestyle. I'm so grateful that we had the courage to do this while we can. It will be one less legal document our son will have to do. Reviewing this book is one of my husband's favorite activities. We do review the book and all the beautiful pictures and the story, and we tell it over and over again. However, we do not review that last section of the book with all the legal documents and our end of life wishes. We will leave this as a legacy for our son and our grandchildren, but it has truly been a needed and necessary experience. And I want to take this time to express my sincere appreciation to the Act 2 team for helping to make this stage and this new chapter in our life a rewarding one, and one that we are prepared for whatever happens in the future. Thank you so much for this opportunity.
Thank you so much, Mrs. Moore. I think that was so inspiring, how you were able to link Kenneth, your dear husband's personal memory book, to what we call, broadly speaking, advanced care planning, the last will and testament, power of attorney, the living will, and other documents. What you are such a wonderful role model for others to emulate. Mm-hmm. Just a quickie question. What do you recommend to others to who may be caregivers or stakeholders, others, maybe others who aren't providing caregiving, but are maybe family members contemplating that possibility. What do you recommend to others to plan for the future?
First of all, I'd recommend they enroll in this program. That's number one. It's an excellent program and it prepared me for where I am right now. Second, you have to take care of family business. Whether it's comfortable or not, you must do it. And it does give you a great deal of peace of mind to know that everything is in order when the time comes.
Thank you. We have a question and a couple comments. Mrs. Moore, if you could give one piece of advice to other caregivers, Mrs. Tamika Norton Brown would much appreciate knowing what that would be.
Well, I'd say everything that you ever want to know about caregiving is in those documents that you provided when I enrolled in the program. And I'll tell you, the facilitators did such an outstanding job. That would be your first task, to get educated, not only if you have to be a caregiver, but it enables you to mentor and help other people as well. So I'm prepared to do that. Even if I never have to do this caregiving again, I am committed to helping other people who need this kind of assistance.
And we have a comment from Mrs. Vicky Rose, a thank you.
Love you. And thank you for the opportunity.
And from Michael Calavetta, outstanding life story. You have a lot to be proud of, Mrs. Moore. Thank you for sharing. Thank you so much.
Yes.
And now we're going to shift to our featured presenter, Attorney Jami Coleman. We're so grateful to have you here. You are not only an outstanding estate planning attorney, but you are an inspiring sister in the Lord. And you know how much I appreciate your presence here.
Oh, thank you, Dr. G. I
Thank
really
you so much.
That. So I have a little bit of a presentation, and I want to talk. I want to talk to your audience about estate planning, why it's important, and go through some of the typical documents that it consists or that is involved when it comes to planning. And so I have this old quote up here that nothing can be said to be certain except death and taxes. And we can move on to the next slide, but that's potentially what I deal with all day in terms of my practice is, you know, probate matters, estate planning matters, and tax and business matters. So I take a lot of joy in doing that, especially for the African American community, because it's a conversation that we don't really talk about as often as we should, that we don't necessarily plan for. We come from historically generations of family members that didn't have plans or thought that it was doom and gloom. And everyone needs to have a plan. You know, everyone needs to have this discussion with their family member as to what things look like in the event that they become disabled or in the event that they pass. And when I say everyone, I'm talking about no matter what your socioeconomic status is. So no matter how much money you make, no matter how much you have in assets, you know, if you only have a bank account, you know, I still would say you need a plan. And so I want to help start this conversation by trying to change the perspective, right? Or our paradigm. So when we think about estate planning, we think about the doom and gloom, or are we foreshadowing our death? Sometimes, some people think of that. And estate planning consists of a myriad of types of documents. And only one of them really has anything to do with your death, and that's your will. And in your will, and I'll talk specifically more about this, but you can also put in how you want to be buried, right? So the next slide is a garden, if you will, or well, before we get there, yes, next slide is a garden. And this is my idea of where I want my wake, right? So I try to keep like a very upbeat perspective when it comes to these things. I want to be in a glass casket, like Sleeping Beauty, in this beautiful garden and have people come and view me. Now that's going to take some planning, right? Because the average funeral is about $6,000 to $10,000 in terms of cost. And if I want something that elaborate, then I need a plan for that, right? One of my favorite movies is Imitation of Life. It's a very old 1959 movie where there is a Black woman named Annie who has a child that could pass for white. And in that movie, Annie is loved by everyone and she passes. And after, when she passes, the whole city pretty much shuts down. Mahalia Jackson is singing at her funeral. The police are escorting her horse-drawn carriage where her casket sits, beautiful white casket, magnolia flowers all over it, maybe 20 or so pallbearers, 4 white horses, beautiful, elaborate funeral. Well, in 2020, that is not a $10,000 funeral. That's pretty elaborate. And so you want to plan for that. Now, I don't sell insurance, but if you don't have life insurance, that's a good way to help, will help with those costs. So for those people that, can get life insurance, I encourage you to look into that. That also goes into planning, So what is an estate plan? Estate plan consists of your will. Okay. It consists of your durable power of attorney, your healthcare surrogate, and your living will. Pretty much those 4 documents. And the will really is talking about what happens to your things in the event that you pass, and where it goes. So your things in relationship to who you love, right? And that's where you will have a personal representative appointed or an executor. You may also have a successor personal representative named in the event that the first personal representative cannot serve. And so the personal representative is a fiduciary. They're the person that makes sure that all your beneficiaries get the assets that you want them to get, and your creditors get paid if necessary, and whatever wishes that you have after death or post-death get carried out. They act in a responsible fiduciary capacity. The next document is a power of attorney. And this document is basically, and I'll talk a little more about that, is that it says that I trust this person to make financial and legal decisions for me. And it's only good while the person's living, okay? The next document, the third document, is the healthcare surrogate. And so in this document, you want to think about who can make medical decisions for you with the help of a licensed physician, right? And then the last document is your living will. That discusses what you want your end of life process to look like. Do you want prolonging procedures if you find yourself in a permanent vegetative state? Do you want a do not resuscitate order? So your living will can consist of those things, and we can move on to the next slide. So when you're doing estate planning, I always try to focus on the person that's in front of me. I always ask them, what is it that you want to accomplish? And we have so many goals as individuals when it comes to estate planning. Most times people are concerned about their family. They want to ensure that their family is protected, that they get what they have acquired or accumulated during their life. So that's usually why they come to me in terms of wanting to get help with their estate planning. One of the other goals that most people may not be aware of, the estate planning is also looking at your assets and learning how to protect those assets. So you're arranging your affairs in such a way that you can protect your assets during your lifetime, and also so that your family or your loved ones can have it for their benefit after your lifetime. Okay. And so we talked a little bit about wills. And basically that's the only document that deals with, your death pretty much. And that's where I want my things to go in relation to the people that I love, right? Sometimes in a will, there may be what's called a standby trust or a children's trust. There's several different types of trust out there. We have revocable trust, we have irrevocable trust, which means you really can't make amendments or modifications to that trust. We have living trust. We have standby trust. That's in the event that someone is a minor or under a disability and they're going to get something out of your will. Those trusts will hold that person's share of your estate until they either become an adult or at a certain age, right? Or if they overcome their disability, right? So me, for example, I have 3 children. I have a 21-year-old, a 16-year-old, and a 2-year-old now. He just turned 2 on Sunday. And if something were to happen to me before I pass, there's a provision in my trust, in my will rather, that has a standby trust. And it says, you can't distribute these funds until they become 25, right? Because we don't want a 21-year-old getting a large sum of money or assets and then hurting themselves. And even at 25, it could be questionable too whether they should get so much. But you can structure those things in your will. You can structure those types of qualifications or those standards that you want your children to meet or your loved ones to meet in order to get to the assets into your will or your trust. So talked about wills, talked about trusts. The next document is probably the most important document, which is the durable power of attorney. And I said I'd come back to that. In the durable power of attorney, this agent is what we usually call them. This power of attorney stands in your shoes, but only during your lifetime, right? They become you only during your lifetime, and they can make financial and legal decisions for you, meaning they can go into your bank account, they can sign over property, they act like you. And so powers of attorneys are extremely powerful, and you really want to make sure that you trust the person implicitly. Okay, I can't stress that enough. You really want to make sure they're going to act like you in the event that you can't act for yourself. And where I see power of attorneys come into play a lot, what are the pros for them, is that should you later in life suffer from a mental impairment, such as Alzheimer's or memory loss or some cognitive impairment, dementia, then and you don't know what's going on, you don't know who the president is, or you're looking at me and you don't know who I am. If you've executed a power of attorney when you were of sound mind and body, you were healthy and you knew what the day was and you knew who the president was and you could comprehend what was going on around you, then that power of attorney will help to avoid, in some cases, a guardianship proceeding, which can be very expensive, right? So guardianship comes into play when you do not have advance directives sometimes. Now, I do see cases where guardianship is present and there's advance directives, but guardianship can come into play. And what that process is you as the ward that doesn't know what's going on has to hire an attorney to represent you, right? And your guardian has to hire an attorney. And then you have 3 committee members in the state of Florida that come out and evaluate you. One's a doctor, one's a licensed maybe nurse, one's a licensed I can't think of a therapist of some sort, but they come out and they evaluate you to see if you're unable to make everyday decisions for yourself. And if they determine that you are unable to do so, they will write up a report, submit it to the judge, and the judge ultimately decides whether you are incapacitated or not. And if you are deemed incapacitated, then a guardian is appointed to you. And sometimes that can be a public guardian, someone you don't even know. Many times it could be a family member, somebody you trust. That's a very expensive process, right? You've got a court process. You've got 3 committee members that you don't know, that don't know you, that's going to write a report. And by the way, they charge for that. And you also have 2 attorneys, one for the guardian and one for yourself. And who pays for that? You do, as the ward, right? So it can be a very expensive process, but it can also be a protective process too. So in the event that you don't have someone that you trust implicitly, guardianship is definitely the way to go, because the courts will review annually what your care has been, where your finances are going. They want to ensure that you're being taken care of. But if you're fortunate to have someone that you trust implicitly, that they are going to act like you, be it conservatively or however you would typically handle your money, your finances, your property, then a durable power of attorney will save you on the cost of having a guardianship later on. And so I encourage everyone to consider that, while there is definitely situations where you do not have someone you trust implicitly, if you do, you want to consider having a power of attorney. Again, that's only good while you're living, okay? The next document that's in your estate plan is your healthcare surrogate. And that's kind of like a power of attorney, but this person is making medical decisions for you with the help of a professional. And you can have as many healthcare surrogates as you want. I encourage people to give those forms to their physicians and also relay that information to their healthcare surrogate. And what often happens is a medical professional will take that form and they will not only use it as an in case of emergency document, but they'll also rely on those surrogates or those individuals to help make medical decisions in the event that you can't make a medical decision for yourself. Okay. The next document, or the last document that usually is in your estate planning document, is what's called a living will. And so some of us may remember the Terry Schiavo situation where the young lady was in a permanent vegetative state, and you had her husband on one side, wanting to remove her for life prolonging procedures, and then her parents on the other side wanting to keep her on life prolonging procedures. Well, very costly litigation. It went all the way up to the Supreme Court. And we think about that case as an extreme situation. But had that young woman had a living will, that may not have been the case. It may not have had to go through those extremes. Had she indicated that, should I find myself in a permanent vegetative state, there's no probability of me coming back, maybe I'm completely brain dead, give me food, water, and medicine to make me comfortable, and but let me go. Or I've even done living wills to say, we have what we call a Catholic living will, where you, because these are really hard decisions, but you say, I have a relationship with God. I don't want to do anything offensive to God. But if I am in a permanent vegetative state, then just let me go. Okay. You can say, I want to stay alive for 2 weeks. But I ask people to really consider, even though it can be, a little bit of a doom and gloom thought to have, I ask people to consider doing a living will one way or the other. Whether you want to be kept alive indefinitely, or you want to just let me go and don't give me anything, food, water, or medicine. Because family, when they make that decision for you to pull the plug or to stop life prolonging procedures, that can be very hard on them. And many times we're planning for our family. And so I've seen situations where you have family members fighting with each other long after the person has died, blaming each other for the death of that person because they had to make a hard decision about whether to keep this person on life prolonging procedures or let them go. So I ask people to, consider having a living will. So I talked a little bit about the goals, goals such as protecting your family. Most people want to, plan for their family, but there's also other goals like asset protection and long-term care planning. And so when you're planning for your family, which is one of the more primary goals, you want to determine, when I'm planning for you and you're thinking about your family, you want to determine, who needs what and how are they, right? So like, going back to my 21-year-old, he's in college. I love him to death, but he's got a very nice wardrobe. He loves shoes. He loves, nice outfits. I don't know that if something were to happen to me, that I would want him to get, a third of my life insurance policy or whatever asset that I have at 21 years old. So I have what we called a spendthrift trust, where he gets a portion of those funds over his lifetime, so as to not harm him. What if you have a family member that has special needs, or they need government assistance? Well, if something were to happen to you, them inheriting so much of your estate may ruin their government benefits. So we think about special needs trusts. So those are some considerations that you want to think about. Who is my family? Who stands to inherit? What is their personality like? What's their lifestyle like? Am I hurting them? Am I going to potentially hurt them? Those are some considerations you want to take into account when you're planning for your family. So, just to recap, you want to make sure you arrange your assets in such a way that you can conserve them and protect them so that they can go to your family or your loved ones. And when we talk about asset protection, we also think about what do you own, how do you own it, and is there some inherent protection already available to it? So some assets that people have that do have some protection is your your homestead, your pension or retirement accounts. Just as an example, so O.J. Simpson, he won the criminal case, but he lost the civil case. So what does he do? He takes his NFL pension and he comes down to Florida, because in Florida, your pension, the principal in it, is protected, right, from creditors. That's what we're talking about from asset protection point of view. Is your assets protected from creditors? In Florida, your homestead also has the constitutional protection. And we're not talking about the tax exemption that's involved in homestead. We're talking about the creditor protection. So only the bank and the government can get into your home. And so there are assets that are protected, and we want to keep it that way during your lifetime. Let's see. Other assets include other real property. So not your homestead may not have asset protection depending on how it's titled. So if you have property titled as husband and wife, meaning the marriage owns the property, well, that has its own inherent asset protection in such a way, right? If the married couple keeps all their liabilities separate and all their assets joint as husband and wife, well, then there's no joint asset of the joint liability. There's no marriage liability that can attack that marriage asset, right? So just as an example, say you have a married couple, they own their second piece of real estate, not their homestead, as husband and wife, and husband goes and gets a Discover credit card and a judgment against him. Well, Discover credit card cannot get into that second home, because that marriage owns the second home, and the creditor only belongs to the husband, not to the marriage. So that's what I mean by you want to keep your assets, if you're married, joined as husband and wife, and your liabilities separate. Bank accounts have no asset protection unless they're titled, again, maybe as husband and wife if you're married. Bank accounts are also very interesting, and I'll get to a little bit later on that, but I do have some cases sometimes where the only asset in someone's estate is the bank account, and you want to avoid probate. That can also be a goal, avoiding probate. You want to avoid probate as much as possible, and you can do that by naming someone as payable on death beneficiary on your bank account. And that's a way to ensure that that person gets those funds or that trust, if you want to create a trust, gets those funds and it goes to where you want it to go without them having to go and hire an attorney. To hire an attorney to do a probate can be anywhere from, $2,500 to $3,000. And so if there's only $2,000 in the bank account, well, most people would say that doesn't really make any economical sense. So when you look at your assets, you want to think about the type of asset that you have. How do you own that asset? What's the title on the asset? Do you have insurance on the asset? These are all considerations that you would make when we're talking about, are your assets protected? Should they be in an LLC? Should they be in a family limited partnership? So I talked about a little bit titles when I said husband and wife. Husband and wife is a form of ownership, but the legal term is tenants by the entirety in Florida. So tenants by the entirety means as husband and wife. Another way to own things is individually, right? Another way to own things is joint tenants in common, which means you own it 50-50. Another form of ownership is rights of survivorship. So me and Susie Q own property together. When I pass, 100% of that property goes directly to Susie Q and doesn't go to my children. That's rights of survivorship. So when I talk about how your assets are titled, that's what I'm talking about. How is it owned? What's the form of ownership in your asset? And so briefly, I said that, some assets have their own inherent creditor protection, life insurance policies being one of them, annuities, qualified pensions and IRAs, college savings accounts, disability insurance, your homestead. All of those inherently have their own asset protection. Cars, boats, planes, RTVs, in Florida, we consider those dangerous instrumentalities. And here I consider those high liability assets, particularly cars. If you go out and you get into a car accident and your policy is insufficient to take care of the claim, well, then you could be subject to a lawsuit individually and your individual assets can be at risk. So you really want to consider, even in the estate planning process, do I have adequate life insurance? Car insurance. How is my car titled? And am I the one operating that vehicle, right? So in Florida, if you get into a car accident, the person not only driving the car, but the owner of the car can also be held responsible for the car accident. So for my parents out there that have their 21-year-olds driving a car that they purchased for the 21-year-old, but the parents' names are still in the car, I'd encourage you to transfer title to your child, because not only could your child be held responsible for an accident or will be held responsible for the accident, but you too, because you own the car. So titling becomes an issue that way, and it becomes a consideration when it comes to asset protection. Real estate that is not your homestead, like investment real estate, second homes, they don't have their own inherent asset protection. So in Florida, they're not constitutionally protected. So creditors can get into the equity of those things. But if you did something like I had suggested earlier, if you're married as husband and wife, you have tenants by the entirety as your form of ownership, that may provide a level of asset protection if you keep all your liabilities separate. Putting it into a limited liability company could be a form of asset protection for that investment real estate, as well as putting it into a family limited partnership. Insurance, we don't necessarily, you wouldn't necessarily think about that being a way to protect your assets, but it is. And we've got like a host of insurance, types of insurance that can help you. And like I said, I'm not an insurance agent, but I do ask these questions, especially when I'm doing an estate planning consultation as it relates to your assets. Do you have life insurance, health insurance? What about disability? What happens in the event that you can't work? What about long-term care? Long-term care insurance is a way to ensure that you're taken care of in the event that you're unable to live on your own. And so those are just some examples of how you can protect your assets, right? Again, another goal is to avoid probate. And beneficiary designations are helpful when it comes to avoiding probate. So if you have a life insurance policy, if you have a pension account, if you have annuities, if you have investment accounts, designating who your beneficiary will be is going to help you avoid probate. So if that person dies that's a beneficiary, then you should definitely update the beneficiary designation with your financial institution. But just like you can do these beneficiary designations with pensions, life insurance, and annuities, you can also do them with your bank. So I would encourage you to go to your bank and make sure you have a payable on death beneficiary. Now, I do get people who say, well, I have this person on my account. You know, depending on who that is, if it's not a spouse, I advise people not to put your children or other people on your account for the purpose of convenience. If they need access to your account, you can always give them a power of attorney. If you don't want them to have that type of access, then you can designate them as a beneficiary so that when you pass, all they'll have to do is get a death certificate, which is about $10, and their ID, and get the funds that way. And that avoids you having to put them on your account and their potential creditors attaching to your bank account. So just to conclude, estate planning is an ongoing process. It's not a one and done deal. You definitely want to get educated. You want to change your paradigm or your perspective about it. It does not have to be doom and gloom. And one way you can think about it is I'm planning not just for my life, but for my family lives, my loved one lives. And that free advice that I gave you was the beneficiary designations on your bank account. So for all of those that do not have that listed on there, someone that you want to get the funds in the event that you pass, it's an easy fix. You know, go ahead and go to your bank and add a payable on death beneficiary. And so I thank you for your time, Dr. G. I thank you for allowing me to present before you. If anybody has any questions, they can reach me. I have my email listed here, and I think I'm open for questions. Did I go over time?
No, you're fine, Jami. We do have a couple of questions for you, and we'll try to get to as many as we can. Michael has stated in your will, and you have two equal equivalent executors. So, for example, can two siblings share as the successors of the will equally?
Great question, Michael. Yes. So you can have two, we call them co-personal representatives. So you can have two executors serving at the same time. Absolutely.
Could we have another one? Oh, Michael says, thank you.
No problem,
Thank you too, Michael, for an excellent question. Do you get to choose the evaluators? Or I'm not sure what. Yeah, go ahead.
When you say evaluators, you mean the executors? It's probably a typo. Yeah. Yes, you do get to, if that's your question, Ms. Thomas, then yes, you choose the executors. This is your will. This is you planning. And, you know, you want to keep in mind that if you don't do a will, the state of Florida will do one for you. So this is an opportunity for you to plan and choose who you want to serve in those roles, because if you don't, the state of Florida will do it for you. And sometimes that's probably not what people want, right? So in some cases, unfortunately, especially as of late, you have young men before they really get to live pass. You know, maybe they have no spouse, no children, never had a job, they pass. And so you may have a wrongful death lawsuit on their behalf. And so who inherits? Both parents. So in Florida, if you don't have a will, we follow what's called the Intestate Statute. So it looks at the decedent, the person that passed. You look to see if they have a spouse, no spouse. You look to see if they have children, no children. You look to see if their parents are living. If both parents are living, both parents take. Well, what if that young man's father wasn't in the picture? What if he never knew who his father was or never got support from his father? Under the intestacy statute, that father gets half, that mother gets half. So yes, to answer your question, you can choose the executors, and I would encourage you to plan so that nobody else has to plan for you.
Vicki Rose has a question for you, Jami Coleman. If the person you are caring for does not have documents, they're no longer able to care for themselves. In parentheses, do they not have the awareness? They do not have the awareness that they can take care of themselves any longer. Do you have to go through guardianship to gain control of their care?
Yes, you do. So if you need to make financial and legal decisions for them, right? So say the facility is requiring that you have the ability to sign documents for them. You're not going to be able to do that if they don't have a power of attorney designating you as the agent. And so if they have some cognitive impairment like Alzheimer's, dementia, memory loss, whatever it may be, but they don't know what's going on and they cannot make decisions for themselves, they can't make legal and financial decisions for themselves, then guardianship would be the next step. And guardianship is extremely, extremely invasive, but very, as it should be, necessary process. Because what essentially happens is a court is saying, I'm stripping you from these rights that you have been given by the Constitution. I'm going to take them. You can't vote, you can't marry, you can't make decisions on how you're going to be socially. They're taking those rights away from you. And so when that happens, the courts want to make sure that you're not able to make those decisions for themselves. And if they entrust what we call the guardian to do those things for you, they want to make sure that they're doing what they're supposed to do correctly. So if there's no advanced directives like a durable power of attorney or a healthcare surrogate in place, guardianship is the next process, and it is a legal process.
Well, thank you so much, Jami Coleman. That was not only highly informative, but it was given in such a down-to-earth manner that that we could understand it. It was highly accessible information. Thank you. We will have time to address other questions during our question and answer period. We are going to shift now to Cornelius Falk's presentation. As I mentioned earlier, Cornelius was the caregiver for his dear grandmother with dementia before she passed. He's also a facilitator and recruiter for the Acts 2 project. Take it away, Cornelius.
Hey, thank you for your time. Thank you for joining us this evening. My journey with the Acts 2 project was generated due to the most influential person in my life living with dementia, and that was my grandmother, Mary Jane Lowder. She lived for 101 years, and I was very fortunate and blessed to have her in the most important times of my life, formative years of my life. My mother was my grandmother's full-time caregiver, and I saw some of the challenges that my mother faced as a full-time caregiver to my grandmother. I wanted to know more about this condition. I wanted to know and learn all that I could to prepare myself to be a caregiver for my parents if and when that time came. I took a proactive approach in my desire to know more about dementia. Though my initial purpose was somewhat selfish, I learned so much from the Acts 2 project, of becoming involved in the Acts 2 project. The journey it's been good and rewarding due to what I've learned and the relationships that I've developed from my colleagues, and most importantly, the treasured caregivers that I've been able to facilitate to in groups. More specifically, in reference to estate planning, my mother took a proactive approach in the affairs of my grandmother prior to her living with this condition of dementia. So that was great. So these decisions were made early on in my grandmother's life. So when the time came for my mom to take care of her affairs, all those things were already set in place. And I think that's what Attorney Coleman was telling you, to take a proactive approach. The sooner, the better, while the person is well, in order to get their affairs in order, to protect them, to protect the rest of the family and their assets. The Acts 2 program includes 7 group skill building group sessions and 5 individual sessions. All of these sessions are delivered weekly over a toll-free telephone by a trained lay pastoral care facilitator like myself. Individual sessions with facilitators focus on goal settings and problem solving to address concerns identified by the caregiver. The program consists of 6 major components: the overview of the basic characteristics of dementia, relaxation training combined with calming prayer and/or meditation, effective thinking about challenges of caregiving coupled with scripture, building in pleasant daily activities as a guard against emotional distress, such as taking walks, listening to gospel music, or reading the scriptures, communicating effectively with the care partner, with dementia, family, and healthcare professionals, being a strong advocate for your loved one, developing effective problem-solving skills through personal goal settings. As Mrs. Moore mentioned earlier, the program not only focuses on the individual that you're caring for, but it focuses on the caregiver and strengthening their skills, abilities to take care of themselves. Number one, you've got to be well in order to take care of anyone else. There are additional resources that are there for the caregiver. There's the Alzheimer's Association, the Alzheimer's Foundation of America, the Florida Department of Elder Affairs, the Elder Hotline, the Elder Care Locator, and the Alzheimer's Disease Education Referral Center. In order to contact the Acts 2 project, interested caregivers can learn more about Acts 2 by telephone, email, or through our website. The phone number is there. Our website is www.acts2project.org, or on our Facebook page, and we're actively on our Facebook Live, which is Acts 2 Caregiver Project. I want to thank you personally for attending this workshop. We will now go to the panel for any questions that you may have.
Before we shift to the panel discussion, Cornelius, it would be helpful to guide people through the website so they know where the links and caregiving resources are. So go ahead, Cornelius.
I'm having difficulty seeing that, Dr. G. If you see it, can you take that for me?
Okay, well, folks, what you should consider if you're on our website is viewing our caregiver resources. And if you wouldn't mind just clicking on to that, Melissa or Chrissy, that would be great. Clicking on to our caregiver resources. There are prayers and readings for caregivers, the basics of dementia, which we've talked about fairly briefly today, the caregiving skills, and then if we shift to the links, we'll be able to look at those. These are Florida-based and national links, ranging from the all's online caregiver sites such as the Alzheimer's Project and the Florida Council on Aging site and several others. And then there are national alternatives that you can link to. Please, if you would like to contact us, please click onto the contact tab, and then you'll be able not only to provide specific to ask specific questions in the window toward the bottom, but you'll also be able to, if you choose to become involved in our 12-session program. And now we'll shift to our panel. We have a number of questions from the audience.
I see a couple of questions, Dr. G. Okay, so what if you cannot afford guardianship? So if the person that needs the guardian can't afford guardianship, then say they're on Social Security, then you can probably get the guardian to get a legal aid attorney or someone to do it pro bono. There are court fees involved, and if you're indigent, you don't have the ability to pay the court fees and the clerk designates you as so, then those fees will be waived. But you will need to at least talk to an attorney to get the process started. As for the other people, like the attorney for the ward is what we call the person that needs the guardian. The attorney for the ward would get paid for if they don't have any assets or they qualify, then they would be paid by the state, and the other committee members would be paid by the state too. So while it can be an expensive process, if you qualify because of financial hardship or restrictions, then there are ways to still do the process and not come out of pocket. So I hope that answers your question, Ms. Rhodes.
We have a question from Tamika Brown. Is there a cost to participate in Acts 2?
No, there isn't. The Acts 2 program doesn't cost you anything, just some time, but it's very beneficial time. So no cost involved to the caregiver.
Dr. Angela Hill says, great information. Thank you, Dr. Hill. Appreciate your affirmation, Michelle Ashley. Another question from Michael Calavata to Attorney Coleman. Is a durable power of attorney required to be drawn up by a lawyer, or can you create the POA informally and have it notarized?
Yes, you can absolutely create it informally or without a lawyer. I think is probably what you're asking. You can go to LegalZoom, you can go to Rocket Lawyer, you can do it yourself, but you want to keep in mind that the durable power of attorney does have to be witnessed by at least 2 people and notarized, and they all need to be within the presence of each other. You also want to keep in mind that the durable power of attorney is only going to allow you to do what it says in that document. So if you are trying to get access to a bank account and it doesn't say that you can, well, then you won't be able to. So you just want to keep that in mind, that you're going to be restricted to that. And you keep in mind, too, that it only is as good as you're living. So once that person dies, that power of attorney is no longer active.
Thank you, Jami Coleman. Any other questions? Tamika says, thank you for making a somewhat confusing topic much clearer. Excellent info. Michelle Scott Carter says, thank you. Thank you, Michelle, for your affirmation. I have a question for you, Jami. Sometimes, I've had questions myself from folks who are in the process of making decisions for a loved one who's hospitalized and maybe comatose or going in and out of consciousness, regarding the rights of the person who has power of attorney. Sometimes I've encountered that there's confusion between what a guardian with power of attorney can do and those who are health surrogates. designated health surrogates. Could you differentiate the rights and roles of those of a power attorney, of a guardian, and also a health surrogate?
Sure. A lot of that confusion stems from all of that being jumbled into one document sometimes too. And so for medical professionals, that can make them a little nervous about, who has the ability to make certain decisions when you have powers listed in both the healthcare surrogate and your power of attorney. So as a practice, I keep those documents separate. But to answer your question, a power of attorney is typically the agent that's going to make financial and legal decisions. So they're making decisions about your money, your property, not necessarily your body or your health, right? Whereas a healthcare surrogate is making decisions about your medical needs, about your care, and they're doing that with the physician most times. So that's how I differentiate them both. Now, you can have a power of attorney that does also designate medical directives in there, but I tend to see that that's where some of the confusion comes in, and so I keep them separate. I also keep them separate because just because this person can handle my financial and legal decisions for me, so they're my power of attorney, they may not necessarily be qualified to help me with my medical decisions, right? I'll use me personally. And today's my mom's birthday, but I tell her all the time, don't take this personally, Ma. I use you as an example all the time, but here's the example. I would not let my mom be my power of attorney to make financial and legal decisions for me. That means she has access to my bank account. That means she can go to St. John and buy her outfits. And I don't shop at St. John's. I wouldn't want her to use my money for that reason. So she's not my power of attorney, but she is my healthcare surrogate. She knows every medical terminology there is. She knows how to talk to doctors. She's very involved in our care. I trust her to make medical decisions for me. And so that's how I would differentiate those for you, Dr. G.
That's very helpful. We have time for one final thought from each of our three panelists. Mrs. Moore, do you have a final thought that you'd like to share with our viewing audience?
I would just emphasize again how valuable this program, the Acts 2 project, is, and what it has meant to me and to my family, and the confidence it has given me to be the best caregiver that I can for my husband. And I'm grateful that one of our team members had the idea of a memory book, because out of that, I was able to get all those legal documents that we have discussed this evening prepared and in order, so that, again, I can just, be at peace that is not something at the last minute that my family has to take care of. So I thank you for this program, because it has done so much for me personally and has enabled me to take care of some end of life decisions.
Just wanted to thank you personally, Mrs. Moore, for your openness, your willingness to share your particular walk with your husband, Kenneth, and your faith walk as well, as a Christian educator and a model for us to follow in terms of putting faith into action.
Yes. Thank you.
Thank you so much. Cornelius Fox, do you have a final thought?
I'm very excited about the Acts 2 project, excited of being involved in it, but the Acts 2 project needs caregivers, it needs facilitators, so we need you, and this is a very important project that's needed in our community. So please come aboard. We need you and want you.
Thank you. And Jami Coleman, final thought before we just have a few announcements before we close it tonight.
Sure. So I'll end it with one of the biggest misconceptions about estate planning is that you need to have a lot of money or a lot of assets in order to have one. And that's just not the case at all. So everyone should have a plan, and everyone should have it written down. Okay. And the last thought, Dr. G, is just to thank you so much for what you're doing. The outreach, the awareness that you're giving to this community is invaluable, and it stretches well beyond what's going on tonight. And thank you, Mrs. Moore and Mr. Cornelius, for this great presentation. I've also learned so much from the two of you.
Thank you.
We have a comment. This is very good information. Thank you, Attorney Coleman. Thank you, Tiffany.
Thank you, Tiffany.
I just wanted to give you just a couple announcements before we call it this evening. Thank you, Jean O'Con. Thank you so much for your positive feedback. We appreciate it. It's a great blessing to have such an enthusiastic audience and dedicated individuals such as Mrs. Moore, Mr. Falk, and Attorney Coleman to provide this information across the state. I have just a brief announcement. As I said, Mrs. Vicki Rose is going to be presenting a very important topic Thursday, October 8th, responding effectively to challenging, to difficult dementia caregiving situations. And I've had a chance to actually participate and to be directly involved in Mrs. Rose's difficult, challenging situation workshops. And it's really it's a must-see. You'll benefit greatly from that upcoming workshop. If you're a care partner of an older adult with dementia who's having some challenging situations, or if you're a family member or just an interested stakeholder to learn a little bit more about some of the challenges that care partners with dementia, family caregivers face, but also to know that there are strategies that can be implemented to work for both the caregiver and the person with dementia to reduce the level of strain that sometimes emerges from challenging such a situation, such as having bladder or bowel accidents, repeated questions, and at times difficulties with cooperating in bathing or eating. At any rate, that's coming up October 8th. That's a Thursday. It'll be 7 to 8:15 p.m. Eastern Time. Also, I would be remiss without thanking two persons who are behind the scenes. We have Chrissy Souders, who has produced this program, and my dear colleague, Melissa Powell, who's been pushing the slides. These two ladies are a great blessing to us. They're unsung heroes. I know you can't see them at this point. I can see them, but you can't. They have contributed significantly to making this a quality production and hopefully an event that and the way it's produced that makes it interesting. Thank you, Chrissy. And she's great with banners. Boy, this constant. Right on top of it. We really thank you for joining us today and have a very good evening.